Well, hey everybody, can you believe it has been a year since the epic fair use rulings in Kadrey and Bartz? Well, now, over here in Kadrey, a full 12 months later, now the plaintiffs are making a motion to appeal it. Yes, they want to do an interlocutory appeal and take it up to the Ninth Circuit. Why? And what took them so long? We'll get into it, but this was actually from a couple of weeks ago, but I wanted to wait to cover it until we had Meta's response because that was always going to be the big story. So a lot of this first part where we cover the plaintiff's motion, a lot of this is going to be review and it's going to be stuff we'll talk about in Meta's response anyway. So if you want to skip to that, you can just use the time codes below. But before then, as we get into this, we are going to start off in a weird sort of way. We're going to start off with a footnote, but this footnote's important, and Meta will be talking about it. This is about what the appeal is not. Plaintiffs reserve the right to appeal after final judgment the court's other summary judgment holdings, including that market dilution. You know, we've been talking about that. That's that brand new theory they're trying to stuff into the fourth factor that isn't there in the law, that isn't there in Supreme Court precedent. They just want to conjure it out of thin air and stick it in there. Is the only viable market harm under fair use factor 4, even when the piracy created a pure market substitution. This was the one, if you remember my coverage on it, and I'm going to link to my older videos where I cover those too in case you want to review those, because they were epic. They were pretty epic, but if you remember, I was saying that Chabria was trying to split the baby. Just throwing them a bone with this market dilution thing, but it has nothing to do with this appeal. That's the point. They're going to appeal that after it's all over. Which is what you normally do with appeals. You only do an interlocutory appeal if there's something so important it has to be taken care of now. And we've talked about those before. So they say, the court's order denying plaintiff's motion for partial summary judgment and granting Meta's cross motion addresses a critical issue of copyright law raised in dozens of pending cases nationwide. Whether AI companies may download copyrighted works from shadow libraries of pirated works and claim fair use by pointing downstream to an ultimate or even potential use for AI training or anything transformative. Because as I've said before, if it's transformative, nothing else matters. It's fair use. This is a pivotal question of law that no court of appeals has addressed. As we'll see in Meta's response, this is a lie. The Supreme Court talked about it in Campbell, and about which there are substantial grounds for differences of opinion. Indeed, as this court has recognized, the only two orders to address this so far, in this case and Bartz, reached opposite conclusions, and since those decisions issued last summer, 18 lawsuits and counting have brought shadow library claims that turn on this same question of law. AI companies have copied and ingested millions of copyrighted text to build large language models, and some, like Meta, have obtained these copyrighted works by reproducing them from illicit repositories built on the systemic piracy of intellectual property instead of purchasing or licensing them. Whether this acquisition practice constitutes a fair use is a multi-billion-dollar question that will shape AI and intellectual property practices and the future of shadow libraries. And by shadow libraries, they're talking about things like Anna's Archive. Bartz held that Anthropic's downloading and retention of copyrighted works from a shadow library was a different use, which this court also held. To be sure, Meta's downloading is a different use from any copying done in the course of LLM training, and had a different purpose from training large language models, thereby undermining a finding of fair use. The downloaded pirated copies used to build a central library were not justified by a fair use. And in a quote down below, they quote him further saying, such piracy of otherwise available copies is inherently, irredeemably infringing, even if the pirated copies are immediately used for the transformative use and immediately discarded. Oh, wait till I cover Meta's response. Meta's gonna talk about the next sentence. What the judge said next. Quote mining, gotta love it. So this court said that because Meta's ultimate use of the plaintiff's books was transformative, so too was Meta's downloading of those books from shadow libraries. But they also quote Judge Chabria saying, it would be nice to get some answers from the Ninth Circuit, particularly on the issue the Judge Alsup and I disagreed on, namely the question of whether, downloading stuff from the shadow libraries is automatically copyright infringement, even if you're downloading it for a fair use. But the Supreme Court basically already said that. At the heart of this case is whether Meta must try to justify its initial unauthorized reproduction in the context of the pure market substitution of stealing rather than buying plaintiffs' copyrighted works, or whether Meta can elide that inquiry altogether by embedding its fair use defense in subsequent separate copying and use of its works in training AI. The training of generative AI models have already produced an intra-district and thus intra-circuit split on the issue, and if you look at the footnote, you see that they're actually referencing Edward Lee, fair use in the origin of AI training. And you're thinking, but that's not a judge's decision. That's not a Supreme Court precedent. Why are they talking about that? Good question. Meta will have something to say about that. Bartz rejected Anthropic's assumption that the use of the pirated copies for a central library can be excused as fair use merely because some will eventually be used to train LLMs. Likewise, this is another good one, the U.S. Copyright Office, which really has no lawmaking or precedential authority, in addressing generative AI copyright issues, has stated that copyright owners have a right to control access to their works, even if someone seeks to obtain them in order to make a fair use. Again, Meta's going to feel a certain way about this. Here, the court's certification of an interlocutory appeal would particularly advance termination of litigation, including by increasing odds of settlement. Yes, they're basically admitting they just want to bully Meta into settling. Yeah, Meta will have something to say about that too. Alright, and finally they say, the question of whether Meta's ultimate use of copyrighted works in connection with AI training excuses Meta's unauthorized acquisition of those works from shadow libraries is a novel and highly consequential issue, and one that has already been the subject of disagreement among courts in this district. A decision by the Ninth Circuit on this issue will not only be pivotal to this case and others, but will have far-reaching effects that shape the contours of generative AI data acquisition practices and the intellectual property rights of millions. All of these factors counsel in favor of certifying the summary judgment order for interlocutory appeal under 28 U.S.C. Section 1292B. Signed, this ambulance chaser. Okay, enough of that. Let's get to what Meta has to say. Meta's response, this is the main event, their opposition to the plaintiff's motion to certify summary judgment for interlocutory appeal pursuant to blah-bitty-blah-bitty-blah. Alright, Meta says, the question that plaintiffs claim justifies interlocutory appellate review is whether downloading of pirated works is categorically ineligible for the fair use defense under copyright law. This issue does not warrant interlocutory certification under Section 1292B. The court's conclusion that fair use applies to Meta's downloads was not the result of a novel legal determination, but the court's application of established copyright law to the specific and undisputed facts of this case, a case-specific inquiry that Section 1292B does not reach. This alleged conflict with Judge Alsup's decision in Bartz is illusory and manufactured through selective quotation. They quote mining like a creationist. Copying from shadow libraries is inherently irredeemably infringing, even if the pirated copies are immediately used for the transformative use. While omitting the very next sentence of the opinion, this order need not decide this case on that rule. Details. Judge Alsup instead denied Anthropic's motion for summary judgment based on unique facts with no counterpart here. Anthropic had allegedly constructed a general-purpose central library of all the books in the world and retained it for non-transformative uses beyond AI training. That is not a legal conflict evidencing a controlling question of law, but rather the result of fair use doctrine operating as it should. And when a motion for Section 1292B certification was later presented to Judge Alsup in Bartz, he denied it by emphasizing the specific factual record that led to that decision. Bartz thus never relied on the bright line rule plaintiffs attribute to it, i.e. that copyrighted works downloaded from internet repositories are per se ineligible for fair use, even if later used for transformative purposes. Which, of course, is how the content cartels want it to be. No matter what you do, you just pirate it and therefore you're guilty and nothing else matters. Which, as I'll show in a minute, is what neither judge in neither case said. In fact, they both agreed that it wasn't. So, that's the big problem here. And for good reason, as fair use calls for a case-by-case analysis that is not to be simplified with bright line rules, going to Campbell. Whether copies downloaded from internet repositories qualify as fair use is inherently case-dependent and not the type of controlling question of law Section 1292B requires. Nor would an immediate appeal of the summary judgment order materially advance the ultimate termination of this litigation. Plaintiffs waited nearly a full year to seek certification, which is itself a reason to deny the motion. Plaintiffs assert that circumstances have changed since the court's order, but in truth, they have changed in a way that makes an interlocutory appeal less appropriate than it would have been a year ago. Plaintiffs have not requested a stay. Moreover, the appeal envisioned by plaintiffs would, at most, address a sliver of the summary judgment order on an issue that might have little to no relevance by the time of the Ninth Circuit's decision, in light of intervening developments such as class certification proceedings here and differences in the factual records developed in the related cases. As for plaintiffs' argument that appellate clarity may improve the prospects for settlement, courts have doubted whether this is even a valid consideration, because resolution of a disputed issue in any case could make settlement more probable. And again, the whole idea here should not just be to bully someone into settling. It should be because you think you have a case you can win, not just vexl it. Even on its own terms, plaintiff's settlement theory assumes a favorable outcome on appeal, ignores that settlement value in a class action turns primarily on certification prospects, as to which this court has expressed doubts, and rests on a chain of speculation that Section 1292B does not permit. Plaintiffs invoke the historic significance of AI copyright issues and the urgent need for appellant guidance on transformative legal questions, but the narrow question they propose to appeal about downloading digital copies from internet repositories is one of the more straightforward and unremarkable issues resolved by the court's order. The genuinely novel issues in this case, including this court's market dilution theory under the fourth fair use factor, are ones plaintiffs have expressly reserved only for a later appeal after judgment. Section 1292B does not exist to send easy questions from a court order to the Ninth Circuit through a piecemeal appeal while parking the harder and more significant ones from that same order for a later day. Plaintiff's motion should be denied. So the plaintiffs don't even have a controlling question of law. Plaintiff's motion rests almost entirely on the order denying summary judgment in Bartz, issued 2 days before this court's ruling. They argue that decision placed that court in direct legal conflict with this court by adopting a categorical rule that fair use can never apply to works downloaded from so-called shadow libraries. A closer look at Bartz exposes the falsity of this premise. The Bartz decision turned on facts specific to that case that are not present here. Judge Alsup also concluded that Anthropic downloaded the plaintiff's books to create a general-purpose central library of all books in the world, which was intended for a broader range of uses beyond LLM training. And Anthropic wondered what that could possibly be, since they're just an AI company. They're like, Judge, what else do you think we're going to do with this? We're an AI company. That's all we do, and speculation into anything else they might do, that's kind of in Minority Report territory, isn't it? That's the big problem with Judge Alsup's decision. The selective quotation of Bartz at the core of plaintiff's argument illustrates the problem. Plaintiffs quote and lean heavily on Judge Alsup's statement that such piracy of otherwise available copies is inherently irredeemably infringing, even if the copies are immediately used for the transformative use and immediately discarded. They omit the next sentence of Judge Alsup's order. This order need not decide this case on that rule. And then further explaining, Alsup said, Anthropic did not use these copies only for training its LLM. Indeed, it retained pirated copies even after deciding it would not use them or copies from them for training its LLMs ever again. They were acquired and retained as a central library of all the books in the world. Building a central library of works to be available for any number of further uses was itself the use for which Anthropic acquired these copies. The Bartz decision discusses the central library dozens of times, including in every section in which it applies the fair use doctrine to the digital copies Anthropic downloaded from internet repositories. The concluding summary in Bartz makes the point explicitly. We will have a trial on the pirated copies used to create Anthropic's central library and the resulting damages, actual or statutory, including for willfulness. So he's not even saying the central library is bad. He's just saying that's a question for the jury, or at least at that point when the record's been developed. This point was further amplified in Judge Alsup's subsequent order, denying Anthropic's motion for appellate certification. Anthropic had presented a one-side and sanitized version of how the works were downloaded into its collection, further copied and in fact used. The court observed that the evidentiary record was unclear, but that the summary judgment record nevertheless supported that Anthropic had downloaded pirated libraries to build its own library for further uses, only one being to make further copies for training LLMs. Even though training LLMs is all they do. The court made clear that Anthropic would have every opportunity to perfect its affirmative defense at trial, presenting evidence for the jury to find the underlying facts needed for the judge to decide fair use in its favor or not. So that's a question for later. Bartz thus never adopted the bright line rule that plaintiffs attribute to it, i.e. that copies downloaded from internet repositories are per se ineligible for fair use as a matter of law, even if later used for a transformative purpose. Any such rule would have been inconsistent with Supreme Court precedent eschewing such bright line rules, survey says Campbell. At any rate, there was no evidence or allegation that Meta created any general-purpose central library for books unrelated to AI research and development. As the court observed in its order, Meta offered unrebutted evidence that plaintiffs' books were downloaded and used solely in connection with the research, development, and training of Meta's AI models. Let me just show you what I've been trying to describe all this time. I can do it better, I think. Man, it doesn't take long for cables to get tangled, does it? Alright, so let me show you this. So in both cases, Bartz and Kadrey, you start out with a download. And then from there, you do something with it. And you do something else. And at some point, you do something that is transformative. Yes, my handwriting's terrible. Then after that, no matter what you do, and you do that, and then you have your final output. That's your final output. As long as any step along the way is transformative, nothing that happens before that matters. So it doesn't matter how you downloaded it, what the other stuff was doing. The transformativeness breaks that chain. So the question is, given that AI training is transformative, spectacularly so, the most transformative we'll see in our lifetimes, etc., why are we still here? Well, what Judge Alsup said is that they're coming off of here and doing something else. They're making a central library. And since that central library was for future unknown purposes, then that made it infringing. That's not what Judge Chabria said in Kadrey at all. The problem there is that because of the way BitTorrent works, when they were downloading, they were also uploading. And so that's the problem. Neither the central library or anything that came from it, or the uploading, the seeding when they downloaded with BitTorrent, none of that was in that chain of stuff that became transformative. So although they both said it in different ways, what they both agreed was that it's not the case that just that initial download was infringing, because as long as it's just that top chain that's transformative, then the output is fine. what the plaintiffs are wanting and what all of these other AI plaintiffs are wanting, that just the mere download of it makes it per se infringing and nothing else matters. That's not what either judge said. So, getting back to it, plaintiffs' inability to show a substantial ground for difference of opinion flows directly from their mischaracterization of Bartz. Because Bartz did not adopt the bright line rule plaintiffs attribute to it, there is no genuine conflict for the Ninth Circuit to address, let alone resolve. They're misrepresenting what the conflict is entirely, as I just showed you. Anthropic created and retained a general purpose library for multiple non-transformative uses. Meta did not. Different facts produce different fair use outcomes. That is not a conflict worthy of immediate circuit level attention. It is the fair use doctrine operating in the way it's supposed to. The court's holding that because Meta's ultimate use of the plaintiff's books was transformative, so too was Meta's downloading of those books, that top line I just showed you in the diagram I made, was not only consistent with established copyright law, but on the particular facts of this case, not a close question. The only other judicial authority plaintiffs cite to attempt to show a substantial ground for difference of opinion is Atari. That's in the Federal Circuit. That's a completely different thing. That's for like contract laws. You got a federal contract and you got a problem with it. That's the circuit you take it up to. This court correctly rejected it because Atari overread the cases on which it relied for its statement about the need to start with an authorized copy. The authorized copy statement cited by plaintiffs has not been adopted by the Ninth Circuit or any other circuit in the more than 3 decades since Atari was decided. It's a complete outlier. Plaintiffs also cite, God, I love this when they do this, a pre-publication Copyright Office report from May 2025 on AI training. That's even before these two decisions. But that report undercuts their position and is hardly precedential. So the Copyright Office has no authority about this. This was a pre-publication report anyway, and it doesn't even say what they claimed it did. Knowing use of a pirated dataset should weigh against fair use without being determinative, a statement immediately followed by a footnote citing cases, including some in which courts found fair use, notwithstanding defendants' use of unauthorized initial copies. The report thus does not support plaintiffs' argument that use of a pirated dataset is categorically ineligible for fair use, even when those works are used for a transformative purpose. The report further confirms that fair use of a pirated dataset is not the type of determinative legal issue for which Section 1292B certification may be appropriate. Plaintiffs also quote a portion of a sentence from Edward Lee. But the full sentence from Professor Lee's article actually says, in short, in denying fair use as to this library building, you see, that was the part they left out, Judge Alsup took a categorical approach, treating the acquisition of pirated books as virtually per se infringing. The sentence immediately before that explains that Judge Alsup had suggested without deciding that Anthropic's fair use defense would have failed, even if Anthropic had downloaded the pirated books without storing them in a permanent library. In fact, another section of Professor Lee's article, not cited by plaintiffs, correctly characterizes this categorical approach as dicta. Professor Lee's article underscores how plaintiffs have misinterpreted Bartz and further undermines plaintiffs' argument that a substantial ground for difference of opinion exists with how this court applied fair use to downloaded copies. And also, an immediate appeal here would not shorten the path to final judgment. Ninth Circuit interlocutory appeals can take years to resolve, and an extended delay is even more likely if, assuming plaintiffs are to be believed, their appeal would present a pivotal question of law that no court of appeals has addressed, in which the practical stakes for both rights holders and AI companies are enormous. This delay is exacerbated by the fact that plaintiffs inexplicably waited almost a full year before requesting certification of summary judgment order under Section 1292B, and they have not asked for a stay of the remaining claims in this cases or the related cases pending any interlocutory appeal. Plaintiffs' delay is reason alone to deny their motion because a district court should not grant an inexcusably dilatory request for certification under Section 1292B. The remaining claims in this case and in the related cases will advance regardless of what happens before the Ninth Circuit. Plaintiffs' inexcusable delay in seeking certification makes it more likely that the district court cases could reach trial, final judgment, and even the early stages of Ninth Circuit review under Section 1291, while plaintiffs' proposed piecemeal Section 1292B appeal is still pending. And even if the appeal is resolved before trial in this or the other related cases, the Ninth Circuit will at best have issued a ruling on a narrow slice of the summary judgment order. That ruling may, by that time, have marginal relevance given intervening develops on class certification in this case and differences in the factual records developed in the related cases. And if the Ninth Circuit affirms this court's ruling, which in Meta's view is the far more likely outcome, the interlocutory appeal would have consumed years of party and judicial resources while providing no countervailing benefit. This waste of resources is further exacerbated by the exceptionally narrow and piecemeal nature of the Section 1292B appeal that plaintiffs envision. Plaintiff's motion is laden with rhetoric about the historic significance of the AI copyright questions this case presents and the need for appellate guidance on these transformative legal issues. But the actual appeal they have proposed is something else entirely. The question is among the more straightforward questions this litigation has generated. It turns on the application of settled fair use principles to a specific set of facts, and does not implicate the novel and genuinely consequential legal questions that plaintiffs suggest make this case so important. In a footnote, you remember the footnote, we started with the footnote, plaintiffs announced that they reserve the right to appeal after final judgment the court's other summary judgment holdings, including the court's market dilution theory under the fourth fair use factor. That is the kind of novel legal development that could warrant attention on appeal, but plaintiffs are not seeking to discuss it in their proposed appeal, presumably because they offered no evidence whatsoever to support it at summary judgment. Plaintiffs want to park that issue and every other issue in the summary judgment order for a later day, while asking this court to send to the Ninth Circuit the more pedestrian question relating to how a particular category of digital copies was obtained. The Ninth Circuit has directed that Section 1292B be applied sparingly and only in exceptional cases. This is not one of them. The motion should be denied. Yeah, all of this is going up to the appeals court and probably even the Supreme Court at some point. And ordinarily I would say the sooner we get a good decision, the better. But that isn't this. I don't even know what they're trying to do here, other than just delay, make things more expensive for Meta, and force a settlement. Which would figure, and it would track with what we've seen the plaintiffs do in other AI cases. So, of course, I'll let you know the developments as they come. Thank you so very much for watching. Comments for the Comic God, shares for the Share Throne. Please hit like, subscribe, and the bell. And, of course, donate Dopagosity.tv to keep me doing what I do, whether it's one-time donations or regular support. You can get these videos early and ad-free, and other benefits like live streams and AMAs, so please check that out. Thanks again, and until next time, stay strong and be free.